Right, let me find out who iPhone is. Good morning. Good morning, you're not connected to audio. Good morning. Can you hear me? Good morning. We can't hear you. Try again. Good morning. Can you connect to audio? There you go. Now take your thing off of mute. Bottom left-hand corner, you'll see a little microphone. Take it off of mute and you should be we can then hear you. I'll try a different tactic. Try it now. Good morning. Can you hear us?
Yes.
Excellent. What case are you here on?
The Crotty versus Leonard.
Crotty versus Leonard. Okay, the motion for scientific testing.
Yes, sir.
We did just have that hearing. Talk to your attorney because there was a stipulation.
Okay.
All right. Thank you. Bye.
Yep. Look at it.
All right. Good morning, Miss Indigala. Yeah. Let me get the coffee in first.
That's okay.
Good morning. How are you?
I'm good. Your Honor, I have another hearing as well,
Yeah.
and the client is here. So when we do that one, I will just swap out with her so that the court.
Okay. Well, I did bring in Mr. Lloyd, so we'll start off with that one, and then we'll go to your one after that. So we're here today for the final judgment in Lloyd versus Florkey, 21 DR 600. Please enter your appearance.
Nicole Angelino on behalf of the husband, Caden Lloyd.
Okay. And I can see from the file, and please confirm that an answer and waiver has been filed by the respondent.
Yes, Your Honor.
Is there any reason we shouldn't proceed to final dissolution today?
None that I am aware of, Your Honor.
All right. Madam Clerk, can you please swear in Mr. Lloyd?
Please raise your right hand. Do you solemnly swear or affirm that the testimony you shall give shall be the truth, the whole truth, and nothing but the truth?
I do.
Can you please state your name and date of birth for the record?
Jaden Benjamin Lloyd, February 6, 1989, Your Honor.
Okay. Please proceed, Miss Angelito.
Okay. Mr. Lloyd, who are you currently married to?
Casey Marie Flurkey.
And when was your date of marriage?
It was May 20th, 2020, May 19th.
I'm sorry?
Or it was May 20th, 2020,
Okay. And where were you married?
in Flathead County, Montana.
Okay. And is your marriage irretrievably broken?
Yes, ma'am.
Are there any children of your marriage?
Just a stepdaughter, but none from me.
Okay. And to your knowledge, is your wife currently pregnant?
No, ma'am.
Okay. And to your knowledge, has your wife been a member of the armed forces in the last 30 days?
No, ma'am.
And is it correct that you are an active member of the armed forces currently?
Yes, ma'am.
Okay. Are you and your wife both over the age of 18 and mentally competent?
Yes, ma'am.
Did you and your wife voluntarily enter into a marital settlement agreement dated March 23rd, 2021?
Yes, ma'am.
Do you believe the provisions contained within that settlement agreement are fair and do you have any dispute with any of them?
I believe they're fair and I don't have any dispute.
Are you asking the court to adopt it via its final judgment?
Yes, ma'am.
And prior to, was Collier County your residence prior to being called away for your duty as a member of the armed forces?
Yes, ma'am.
And Your Honor, I believe that's all because Mrs. Flarkey did not indicate that she wanted a name change when I sent her the proposed final judgment.
You may have asked this question, but were you a resident of the state of Florida 6 months prior to filing this petition?
Yes, sir. Yes, Your Honor.
Okay. All right. The court has reviewed the settlement agreement and the rest of the file and notes that an answer and waiver from the respondent was filed on March 23rd. Yes, March 23rd. The court finds that it has jurisdiction over the subject matter and the parties, that at least one party has been a resident of the state of Florida for 6 months prior to filing this petition, and that their marriage is irretrievably broken without any minor children. The court will therefore dissolve the marriage and restore the parties back to single status. The court also finds that the parties have freely and voluntarily entered into a marital settlement agreement. The court will reserve jurisdiction to enforce the terms of the marital settlement agreement. I had received the final judgment from Ms. Angelito and I just signed it. Best wishes to you, Mr. Lloyd, and also to the Ms. Florkey in the future.
Thank you, Your Honor.
And Your Honor, in this particular case, I've advised Ms. Phillips, I did send a hard copy via US mail as I don't have an email address for Ms. Flarkey. So when Your Honor receives that, there's a self-addressed stamped envelope so that we can send this on to her as well.
Perfect. I appreciate that. Thank you, Ms. Angelito. Mr. Lloyd, you may go. And Ms. Angelito, please remain, and we will move on to the next case. Thank you, Mr. Lloyd.
All right. Thank you, Your Honor.
So we're gonna shuffle our seats, Your Honor. So go ahead and have a seat right up. Oh, no, that's okay. He sees me all the time, doesn't he?
Wow, I looked down for a second and Ms. Angelino changed.
Good morning, Your Honor.
Good morning. We're here on the case of Zuleta versus Zuleta, 20 DR 541. Ms. Angelito, please yell your appearance from across the room.
Nicole Angelito on behalf of the wife, Caridad M. Zuleta.
Okay. And I understand an answer and waiver was filed by the husband in this case on March 17th.
Yes, Your Honor.
Is there any reason we shouldn't proceed to final dissolution today?
Not that I'm aware of, Your Honor.
All right. Madam Clerk, can you please swear in Ms. Zuleta?
Please raise your right hand. Do you solemnly swear or affirm that the testimony you shall give shall be the truth, the whole truth, and nothing but the truth?
Yes.
Can you please state your name and date of birth for the record?
Caridad Maria Zulueta, February 18th, 1969.
Okay. Please proceed if you can, Ms. Angelito. If not, I can do it.
It doesn't matter, Your Honor, either or.
It's kind of cool hearing you off screen.
Okay, Ms. Zuleta, who are you currently married to?
Orlando de Jesus Zulueta.
Okay, and have both of you been residents of the state of Florida for at least 6 months prior to filing this divorce action?
Yes.
And when were you married?
Naples, Florida.
And when?
Oh, when? June 19th, 2019.
Wrong answer. You can't.
Oh,
you
June
can't
10th,
get this.
2019.
Okay.
And is your marriage irretrievably broken?
Yes.
Were there any children born of the marriage?
No.
Are you currently pregnant?
No.
Have either yourself or Mr. Zuleta been a party of the armed forces in the last 30 days?
No.
Are you both over the age of 18 and mentally competent?
Yes.
Did you both voluntarily enter into a marital settlement agreement dated March 16th, 2021?
Yes.
Are you satisfied that the terms of that agreement are fair and that you willingly entered into it?
Yes.
And are you requesting the court to change your name at this time?
No.
Okay, Your Honor, that's all I have.
Okay. The court has reviewed the file, finds that an answer and waiver had been filed by the respondent husband on March 17th, 2021. The court finds that it has jurisdiction over the subject matter and the parties, that at least one party has been a resident of the state of Florida for 6 months prior to filing this petition, that there are no minor children, and the marriage is irretrievably broken. The court will therefore dissolve the marriage and restore the parties back to single status. The court also finds that the parties have entered into a marital settlement agreement and that they have done so freely and voluntarily. The court will reserve jurisdiction to enforce the terms of the marital settlement agreement. I received a copy of the final judgment from Ms. Angelito, which I'm signing now. And best of luck to you, Ms. Zuleta, in the future.
Thank you, Your Honor.
Okay. Ms. Angelito, is there anything else?
No, that is all I have scheduled for today, Your Honor.
Okay. Have a great rest of the day then.
Thank you, you as well.
Bye. All right. I don't see anyone here for the rest of our 9:30s. I will get back with you.
Okay.
Good morning, Mr. Meester.
Good morning, Your Honor.
I know we're a little bit early, but I saw that your client was in here, so I figured maybe we can move forward.
That works for me. If Ms. Del Pero, Ann, can you turn on your camera and the microphone? Is that possible?
And take yourself off mute.
There I am.
All right, excellent. We are here today on the case of Del Pero versus Del Pero 21 DR 182. Please enter your appearance, Mr. Meester.
Good morning, Your Honor. Logan Meester for the petitioner, Ms. Ann Del Pero.
All right, and we're here today on a final judgment of dissolution. Any reason we shouldn't be proceeding?
Not on our end, Your Honor.
I see that an answer and waiver was filed on March 8th. Do we have any expectation that the respondent would appear today?
Your Honor, I don't believe so. I spoke with my client yesterday and she does not believe that he will be appearing.
Okay. All right. In that case, Madam Clerk, can you please swear in Ms. Del Pero?
Please raise your right hand. Do you solemnly swear or affirm that the testimony you shall give shall be the truth, the whole truth, and nothing but the truth?
I do swear.
Can you please state your name and date of birth for the record?
My name is Ann Marinelli Del Pero, born October 27, 1950.
Okay. Please proceed, Mr. Meester.
Good morning, Ms. Del Pero. Are you
Morning.
currently married to Pier Luigi Del Pero?
Yes, I am.
Were you married on April 11th, 1979?
Yes, I was.
Did you separate from your husband on or about December 8th of 2020?
Yes.
Are you both over the age of 18?
Yes, we are.
Were you a resident of the state of Florida for 6 months prior to the filing of the petition for dissolution of marriage?
Yes.
Are either of you in the military?
No.
Are you asking for the court to dissolve your marriage because it is irretrievably broken?
Yes, we are.
Are you currently pregnant?
No, I'm not.
Do you and Mr. Del Pero have any minor children together?
No, we don't.
Did you and Mr. Del Pero enter into a marital settlement agreement in this matter that resolves all issues in your divorce?
Yes.
And did you enter into that agreement freely and voluntarily?
Yes, we did.
And are you asking the court to adopt that settlement agreement today?
I am.
Are you asking the court to revert to your former name?
Yes, I am.
And what is your former name?
My former name, Ann Rita Marinelli.
Thank you. No further questions, Your Honor.
Okay, just so I make sure I'm not changing your name to a wrong spelling, can you please spell Marinelli?
Marinelli.
Got it.
Your
All
Honor,
right.
I'm sorry, Your Honor. I did submit a proposed final judgment with the correct spelling and everything else to your office, I believe, yesterday or maybe even the day before.
You did, and I know you do good work. I had an experience where I gave somebody the wrong spelling of the name based on a final judgment, and I just wanted to be clear, make
Very
sure.
good, sir.
The court has reviewed everything in the file and finds that, first of all, an answer and waiver is filed by the respondent on March 8th. The court does have jurisdiction over the subject matter and the parties, that at least one party has been a resident of the state of Florida for 6 months prior to filing the petition. The court finds that there is no minor children and that the marriage is irretrievably broken. The court will therefore dissolve the marriage and restore you back to single status. The court also finds the parties have entered into a marital settlement agreement to resolve all disputes related in any way to assets and liabilities. The court will reserve jurisdiction to enforce the terms of that marital settlement agreement, as the court finds it was entered into freely and voluntarily. Finally, the court will grant your request to have your maiden name restored, and you are no longer Anna Marie Del Pero, but as of this moment, you will be Anna Rita Marinelli. I received the final judgment.
Excuse me, Your Honor. Not Anna, but Ann, A-N-N.
Got it.
Rita?
And, yeah, it's correct in the final judgment. I just misread it.
Okay, thank you.
You'll be Ann Rita Marinelli. All right, I've just signed the final judgment. Best wishes to you, Miss Marinelli, and you can now change your Zoom name.
Thank you very much.
All right.
Thank
Anything
you.
else, Mr. Meester?
No, Your Honor.
All right, thank you.
Have a
Thank you.
nice day.
Bye.
Thank you.
Good morning, Miss Senator Charles. Good morning, Miss Senator Charles.
Good morning, Your Honor. How are you?
Good. How are you doing?
I'm fine, thank you. I am not sure if my client is on.
Reyes Perez. I don't see anyone. Victoria Perez.
I may need to reschedule this. I don't know if
Well, I think you need to reschedule it anyway, because let's talk about this. This is case number 19 DR 1865. First of all, your request for hearing is for a default.
Yes, Your Honor.
But default had already been issued by the clerk.
Yes, Your Honor.
What would we be doing here?
I apologize, Your Honor. I think my assistant scheduled it for the wrong thing. Technically, it was supposed to be for a default hearing on our petition. So
Okay.
I think she did it wrong, and I don't mind rescheduling this, Your Honor, just so we make sure it's done properly.
I think so. I think that the other question I have is, I hadn't seen a petition for concurrent custody by extended family before. I guess I'm confused as why aren't you going through the method of a step-parent adoption? Just based on my read in the petition, I'm not sure what you're asking for is the right method.
Your Honor, it is allowed under the statute, and if I may, off the record, well, I guess I'm not off the record because I see live on YouTube.
We're live on YouTube, but there's no court reporter here. I want to make sure that when you get to the hearing that you're on the right thing.
Yes, sir. It is allowed. And one of the reasons why we have to do it this way, Your Honor, is because this is a way for us to try to, and to be honest, try to get this child legal status under the statute. By doing it this way, we can do that. The step parent wouldn't work because the stepfather cannot give this child legal status.
Okay. All right. So I guess another question for you is there any reason that you can't do a default hearing in front of the magistrate in this case?
If that's your preference, Your Honor, it's fine. I mean, I think I would have to explain to either you or to the magistrate why I'm doing it like that. So yeah, it's fine.
Okay. All right. So obviously I don't think I can do anything today.
Yes,
So
Your Honor.
I think the better course of action for you would be to schedule this with the magistrate and file the notice to do that, because they're very accustomed to doing default hearings like this, because you already have the default. There's
Yes,
nothing
Your
for
Honor.
me to enter today.
Yes, Your Honor.
I still don't see your client in the Zoom room. So, all right. So we're not gonna have any ruling whatsoever today,
Yes, Your
other
Honor.
than the fact that you already have the default that you were seeking.
Yes, Your Honor. Thank you so much.
No problem. Thank you, Ms.
Have a-
Santros.
Thank you. Have a good day.
You too. Bye.
Bye-bye.
Good morning, Miss Orange.
I have to.
Whoa. I can hear myself in surround sound.
Me too. Let me figure this out. I did this yesterday. Let me mute.
Only one device can be on, or else that's going to happen.
Is this? How about now?
I can hear you now.
Okay.
All right. Miss Orange, we're here today for what was scheduled, I guess, as a final hearing, and it was a default case.
Yes.
I can see a whole lot of things were just hit my docket today that were filed.
Yes, so they were prepared, and I did not realize until yesterday that they hadn't been filed. The respondent is also on the Zoom.
Yeah, I can see that, which makes me very concerned for a number of reasons, and proceeding in a default case when the petitioner is present and there's 3 children.
Okay.
I also see that the notice of hearing was filed yesterday, or looks like it was filed yesterday.
It was, but we'd given the notice to the petition to the respondent since the 14th, since the day we prepared it. We had already mailed it to him and provided it to the petitioner, and she gave it to him as well, which is why he's here. I just didn't realize that none of those things were filed until yesterday when I was going through.
Okay. Mr. Reyes, can you hear us?
Yes.
Did you ever receive notice of this case? I mean, did
Yep.
you ever receive the summons?
Yes.
When did you receive the summons?
Like a month ago, I think.
A month ago?
Yep.
And have you filed an answer?
I don't answer.
Are you going to file an answer?
No.
Why not?
Because I'm confused.
Are you going to get an attorney?
Yep.
Okay, here's what I got to do, Miss Orange. We're going to continue this today. I'm going to give you, Mr. Reyes, right now, here's what the current situation is. You have not filed an answer. You've been held in default by the court. So you currently have no standing here to proceed. However, there are 3 kids with this marriage, and a lot of things that should have been filed before appear to be just filed yesterday. I am very uncomfortable proceeding today, given that you're here and saying that you want to be a part of this case. You need to move and move quickly if you were going to first get rid of the default and then do what you need to do to actually move forward in this case. Do you understand?
Can I say something really quick?
Not yet. Mr. Perez?
Yes, I understand. Not too much because I'm not speaking English right, so
okay.
I understand better the talk. But,
all right. Here's what I'm gonna do. Ms. Orange, how long do you think how long do we need to continue this for him to get an attorney?
Well, Your Honor, I did the parenting plan based off of what Mr. Reyes Perez and what Ms. Perez came up with. I didn't just.
So there's an agreement?
It's agreed, but he doesn't want to file the paperwork, which is why we just moved forward with the default and notified.
Yeah. All right. This is way too messy for today. So here's what we're gonna do. Is there any reason, Ms. Orange, this can't be before a magistrate if it is default or agreed?
There's no reason why it can't be. I believe Ms. Perez wanted to address the court.
Is that a good idea, Ms. Orange?
Yeah, it's fine because we've already talked about this, so that's fine.
Okay.
Yeah. The reason he did it that way was because of the fact that we were in agreement with anything, because I'm not going after him for anything extra. We agreed on child support. We agreed on visitations. He can see his children anytime they want. So that's why we were doing it this way.
Okay, that's wonderful news. That's wonderful news. So here's what needs to happen. If there is an agreement, it needs to be memorialized in a marital settlement agreement and all of those things. And then we can do this like that. We can do a very quick one, and I'm happy to reschedule that with me at the earliest convenience, earliest possible convenience, and Ms. Orange can contact my JA. If you can get a marital settlement agreement signed by all parties, we don't have to worry about a default trial. So here's what I'm going to do now today. I need to continue this. Mr. Reyes Perez, if you are going to contest this case, you need to do so as soon as possible. So I'm going to give you 20 days to file an answer. If you're contesting this case. If you're not contesting this case, then that's fine. You can sign whatever the marital settlement agreement is, or an agreement that I'm sure Ms. Orange will be providing at some point soon. If you are contesting it, we need to get it moving, and we'll get it moving in front of a magistrate. So Ms. Orange, you can go ahead and you can schedule your hearings after the 20. If he doesn't respond within 20 days, you can schedule a default trial with the magistrate. Does that make sense?
Yes, and the reason why I didn't have it go straight is because there's an account to the establishment of paternity in it. But I guess, I mean, if Mr. Reyes wants to either hire counsel or come to my office and talk about it, we'll address the court.
Okay. This whole case was just filed in March, so.
It already had everything worked out before they came to me.
Oh,
so,
even better. Okay. So,
the parties have been separated for 4 or 5 years already, and this was just going to be finally just legally divorced. Everything that they've been doing, that's what's in the parenting plan that I filed in court, is the schedule that they've been following. Dad's been paying child support. The parties have just been separated and have been ready to just file. But
okay, this is wonderful. This is much better news than I thought. I thought this was going to be contested. I thought there was a default. I thought we were at a trial, but it sounds like the only thing that needs to be done is paperwork. And it sounds like father needs to also do, I think he needs to do a parenting class and maybe the financial affidavit.
Well, he's defaulted. So I think I don't want to say I think, but his original plan was to default, which is why, I mean, he was just like the quickest way to get this done. If it's going to be me not answering, then I want to get this done. I didn't just go about doing this quickly.
Okay.
I'll
The good news is
how you want.
we can still do it quickly, but I can't do any shortcuts especially with 3 children involved. If he is defaulted and isn't going to be doing the financial affidavit and everything, I still want to see this marital a settlement agreement in writing. That is probably the best way to do it.
Okay.
The baby.
All right.
Can I
Okay,
ask
so
the paternity portion?
I'll answer your question.
the paternity portion, is there any dispute as to paternity?
There's no dispute that the husband's not the father of the last child.
I have a 4th child. That's
Okay.
not.
All right. Well, given this situation, really the best thing for everybody is if this is all memorialized in an agreement, a written agreement that we can look back on in the future. So for all those reasons, I'm going to continue it at this stage. Ms. Orange, can you just please prepare a brief order continuing this at this stage, requiring husband to file an answer or move to set aside the default within 20 days if he's going to do so. And then you can set this for a trial in front of the magistrate in default if that doesn't happen. You can set it with the magistrate regardless if it's gonna, even if he does file an answer.
Okay. All right.
Okay. Is there anything else that we need to talk about in this case?
That's it.
All right. I guess one question regarding, because you were saying that he's not the father of one of the children?
The last child. Yes, the parties separated in 2017 and the last child was born in 2020.
But they were still married at that time?
Yes.
Doesn't that make him the legal father?
Nobody's name's on the birth certificate, which is why they wanted this expedited so that her father could get on the birth certificate. As long as she's married, the last child's father can't be on the birth certificate.
But she was married when the child was born.
Right, and there's no father's certificate.
Yeah, but under the law, if she's married at the time they were born, doesn't that make him the legal father regardless of the birth certificate?
Which is why the count 2 is a disestablishment of paternity.
Okay.
That's why I wasn't sure.
This is I understand what you're trying to do, but this is messy and it's going to take more work than.
Okay, do you want me to put this before the magistrate or come back before you? Given count 2.
What?
Given the count 2 disestablishment of paternity, do you want me to bring this before the magistrate or come back before you?
You're welcome to bring anything before the magistrate that the magistrate can handle. I think that would make a lot of sense. But I need you to make sure that you're looking up the law and what actually needs to happen to disestablish paternity, knowing that I think he's the legal father of the child because they were married at the time of the child's birth, regardless of the birth certificate. I'll have to look at the law on all this, but this is definitely why we need to make sure that this is as clean as possible.
Okay.
All right. Anything else, Ms. Orange?
That's it.
Okay. All right. Best wishes to everyone going forward. I am glad that you all are cooperating in a resolution, and hopefully we'll get you there as soon as possible.
Thank you, Your Honor. Have a good weekend.
Thank you. Bye.